Iconic. An Introduction to the Typology of Islamic Legal Theory by Aron Zysow. The Economy of Certainty. Cambridge, Massachusetts, 1984. This is a summary of Chapter 1 and a great footnote that follows Chapter 1, which I'll also go through. Summary. Rooted in a historical revelation, Islamic law requires criteria by which to judge the authenticity of its material. The Quran and the Sunnah is this material source. The authenticity of the Quran is something that is not questioned, and some part of the Sunnah is guaranteed by their widespread and unbroken transmission. These sources are mutawatir. As to the non-mutawatir traditions, there is disagreement whether they must be of absolute certainty or absolutely certain in their authenticity in order to serve as binding legal norms. Those who required certainty were themselves divided as to whether it could be found outside of what was mutawatir. Generally, however, certainty was not required. A valid norm could be based on traditions of only probable authenticity, unit traditions, the khabar al-ahad. For the Hanafis, there is an intermediate category, which is the standard for those traditions that purport to regulate matters of general concern. They must be mashhur. This is a less rigorous version of the requirement that all binding traditions be of absolute certainty, and like it, is found on theological postulates. Because they imposed such rigid standards for the content of the traditions, the Hanafis were able to adopt relatively lenient requirements with respect to the chains of transmitters. That's the end of the summary, and here is footnote number 2, which is very detailed and will go through some issues. With respect to interpretation, and he takes this from al-Fasih al-Harawi in his book Jawahir al-Usul fi ilm hadith al-Rasul, apologies, no Arabic given, page 18. The major issue in this connection is that of abrogation. Famous was Shafi'i's doctrine that the Quran could be abrogated only by the Quran and the Sunnah only by the Sunnah, paragraphs 322 and 324. This doctrine, defended by Shafi'i in both versions of Ar-Risala, as mentioned by Tusi on page 203, was meant to protect the Sunnah from widespread rejection. This doctrine, theologically retrogressive, was rejected by the majority of Shafi'is, and the opposing doctrine was even attributed to Shafi'i by some of his followers. This issue raises 4 points of general significance in the study of usul al-fiqh. Number 1, the actual doctrine of an early master. Number 2, the understanding of his doctrine by his followers. Number 3, the understanding of his doctrine by his opponents. And number 4, the polemical dimension, illustrated here by Abu Bakr ibn Mas'ud al-Qassani. Some achieved the same result of Shafi'i without his rigid compartmentalization. For the Syrian al-Awza'i, who dies in 157, commensurate with 774, the Sunnah could abrogate the Quran, but not vice versa. So, also for the Muhaddith al-Darimi, who dies 255, commensurate with 869, and Qadi Abul Farraj attributed this, the Kufan view, to Malik, and that is found in Ibn Abdul Bar's Jami' Bayan al-Ilm wa Fadlih. Apologies, no Arabic given. Stay tuned for chapter 2 and many more parts. End.